Yes, good evening to the participants of the students of the SLW 646, that is the Advanced International, what do you say, that ADR and settlement, alternative dispute and its law. And that is the 646 one. And this is the second year first semester course. And let me begin it. And the participants, could you see my screen? Say unmute and say yes.
Yes, Prof.
Yes, I could see here. Mute it. Can you read it? Can you read what I posted on the screen?
Welcome to the students of SLW 646.
Yeah, that is the thing which I made the Professor Dr. Mohammed Saheb, Professor of Law, School of Law, St. Augustine University of Tanzania, post box number 307, Malimbe, Monza, Tanzania, East Africa, and my WhatsApp number also given over there. Now, without wasting the time, let me go to today class is concerned, and this is the course outline. I believe that everybody is having the course outline. Am I right?
Yes, Prof.
Yes,
Good,
Prof.
good, very good. And it is advanced international dispute settlement law. Because the first time that we are using, no, that's why that I could not make it out. I say ADR, but ADR is also the same. Dispute settlement law, it is there. And this is every 3 hours in a week, the class is there, and total 60 contact hours in a semester. That's why we have to complete this course. And if you happen to the course objectives, it is clearly written over there. And the first and foremost thing that what I want to say is the introduction. So now in the introduction, let me see, because there is a dispute, there is a settlement, there is the international. These are the wordings are there, total 3. But let me see what is the difference in a conflict and dispute. So when you say the conflict, an argument or disagreement, especially an official one between, for example, workers and employers, are two countries with a common border, and a bitter long running, it's called a dispute. And conflict means conflict comes at the time. It is not actually the conflict, it is a dispute. It is a dispute. Then what is the conflict? Anyone can unmute and say what is the conflict? The dispute, I already told you. It's a disagreement, especially an official one, between, one example, workers and employers are the two countries with a common border, and a bitter long running, it is called dispute. A land dispute is there, house dispute is there, property dispute is there. But when you say the conflict, how do you say it? Do you know what is meant by conflict? Unmute and say whether know it or no or pasa.
It is a misunderstanding between parties.
Okay, okay. Now let me make it clear to you the conflicts and dispute, because I in the down, can anyone can unmute and read that? What is that? I put it conflict and dispute. Yes. Anyone can unmute and read.
Most people probably don't recognize a distinct difference between the terms conflict and dispute. However, many conflict scholars do draw a distinction between the two terms. As is unfortunately common in this field, different scholars define the terms in different ways, leading to confusion.
Okay. Now I will give the difference how the dispute and conflict would be there. So most people give the different idea regarding the dispute and conflict is concerned, but one way that is a particularly useful, however, is the distinction made by the John Burton. John Burton has used this distinction, which distinguishes the two based on time and issues in contention. These are the two things are there. Disputes, according to Burton, suggest are short-term disagreements that are relatively easy to resolve. So dispute is a short-term disagreements that are easy to resolve. That is a dispute. But when you say the long-term, deep-rooted problem that involve seemingly non-negotiable issues and are resistant to resolutions are what Burton refers to as a conflict. So conflict is a deep-rooted one and the long-term one, and it takes a much time for the negotiation and sometimes seemingly non-negotiable issues. Though both types of the disagreement can occur independently of one another, they may also be connected. In fact, one way to think about the difference between them is that short-term disputes are the disputes and they exist within a longer conflict. A larger time it will be taken, we can say a longer conflict, and a short term will be taken is a dispute. So a similar concept would be the notion of the battles which occur within the broader context of war. So there is a difference of the opinion would be there between a wife and husband. When a difference of the opinion would be there in wife and husband regarding the wife is a capitalist and the husband is a socialist. So there is a conflict of opinions, but don't say the dispute of opinions. It's a conflict of opinions there, not dispute of opinion. Because one school of thought, wife is a capitalistic and the husband is a socialistic. So there is a difference between there, we can say at the time, conflict of opinion is there. Even conflict of decision also there. See, one judge will give the dissenting judgment and another judge will give the assenting judgment. At that instance, we can say it's a conflict between the two. Don't say dispute between the two, because school of thought varies. There the school of thought varies. So that way we can make it out conflict and dispute. And what is a dispute in international law? An international law dispute can be defined as a disagreement on a question of law or fact. Either the question of law or the fact. If any disagreement would be there, we can say international issue or international dispute. A conflict or a clash of a legal views or interests, only state may apply to and appear before the International Court of Justice. When there is a dispute would be there, at that instant only state will appear it. Okay, if there is a dispute between a state and an individual is there, at the time individual will appear it. And especially when the matter comes to the International Court of Justice, an individual will appear against the state. Because if the much state will done and manhandling and torturing the people will approach to the International Court of Justice. At that instance, we don't say it's a conflict, it's a dispute. Okay. And when you say the private international law, we don't say dispute there. No, we say conflict. The conflict in the private international law means one school of thought, another school of thought. One country language, not language. One country legal system and another country legal system. It's a conflict, not dispute. That is a conflict because two legal systems are there. So here what I want to say is, okay, let me go further. Settlement. What is meant by settlement? The best way of justice is settlement. It is a greatest thing. So here the majority of the disputes end in a settlement or compromise rather than being decided by a court. Settlement can be achieved by a simple negotiation or as a result of mediation or some other form of alternative dispute resolution. By using mediation, by using arbitration, by using negotiation, one can come and make the matter settled. So that is the settlement. So here we have to read the settlement. The note looks at all aspects of the settling a dispute by negotiation, including the effect of settlement. Why it is important to try to reach a settlement? The reason is to save the time, to save the money, without prejudice of the status of negotiation, the different way of documenting a settlement, how to enforce a settlement, and how to set aside a settlement. So there may be a settlement, there may be some condition, they will put it over there, both the party will agree to that point, and they say that they want to make end of this dispute by either by the compromise or by the settling the terms and conditions. In the both the way it can be there. So the best justice is settlement. Now if you go further, peaceful settlement of international dispute, because settlement also in uproar, cry also there, force also there, but here peaceful settlement of international dispute is a fundamental principle of international law of a preemptory character. It's one of the major and notable and highly appreciable character is peaceful settlement for the international disputes. It is formulated as such in the UN Charter, Article 2. Is it 3 or 2.3? Yes. Is it 2 or 2.3?
2.3.
Okay, let me check it whether the 2.3 there in the charter or not. Okay, mute. So according to article which is cited over there, mute, and developed in the UNGA. What is UNGA? UNGA, what is UNGA? What is meant by UNGA? United Nations General Assembly. United Nations General Assembly resolution. Mute. 2625. And what is the Roman number? Can you read it? Roman number? If you cannot mute, I can mute also here. Of course you muted, but I don't know why you are getting the sound. Oh, now no sound is there. Amna Shida. What is the number, Roman number? Unmute and read. The Roman number after 2625. It is a 25, 10, 10 and 5. So 25 and the principle of international law concerning friendly relations and cooperation among the states. So friendly relations and cooperation among the states will come to a conclusion of settlement because UN Charter has made such a thing. Suppose if they don't make such a settlement, then naturally enforcement is there. What enforcement? Legal enforcement or economic enforcement. These sanctions are there. So the origin of this principle can be traced back to the first Hague Peace Conference in 1899, which produced a convention for the Pacific settlement of the international disputes. So there is a conference is made in The Hague in 1899 and which produced a convention for the Pacific settlement of the international dispute. So there is a convention will be there. When a convention will be there, who are the parties to the convention and they will bind the decision. Is it clear? Say yes.
Yes.
Okay. Pacific settlement of international. The second Hague Peace Conference, which is held in the 1907, yielded another convention for the Pacific settlement of international dispute. So there are two conventions. One is 1899, another is 1907. What? Pacific Convention, that is the Convention for the Pacific Settlement of International Dispute. With the League of Nations covenant, this commitment to Pacific dispute settlement was reinforced by a moratorium on the use of the force. So now the states' obligation to resolve their differences by Pacific methods gained all its significance when the prohibition of the use of the force was eventually formulated in Article 2.4. So now we cannot use any force against anybody for the settlement because of the UN Charter. So the force will be removed and the understanding would be there, and that is clearly mentioned in the Article 2.4 of the United Nations Charter and Article 2.3 and Article 33. These are also said about the peaceful settlement among the nations. So ICJ, International Court of Justice, also gave the judgment on 27 June 1986, that is the military and paramilitary activities in and against the Nicaragua, that is recorded in the 1986 page number 145, para 290. The ICJ has given, stating that the principle that the parties to any dispute should seek a solution by peaceful means is a complementary to the principle of prohibitive nature. So ICJ made such a statement in the Nicaragua case law and recommending that a peaceful settlement between the parties are there, and that is a complementary to the principle of the prohibitive nature. Instead of the prohibitive nature, peaceful settlement is encouraged by the ICJ in the Nicaragua case. On the basis of this principle, where it's gone? Yes, Article 33 of the UN Charter present a non-exhaustive list of specific method for dispute settlement. Article 33 of the UN Charter, including negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and resort to regional arrangements. By any other mode, the matter would be settled, and that to be peacefully without using of the force. So, an established UN Charter, Article 37.1, should the parties effort to solve their dispute fail, they fall under the obligation to refer it to the Security Council. Suppose in the peace settlement convention, if the party failed to resolve the issue peacefully, then the matter refers to
Security Council.
Council. Traditionally, within the field of peaceful settlement of disputes, much of the international law scholarship attention has revolved around binding method for the pacific settlement. Mostly the binding method of the peaceful settlement is a more important factor, and the less attention has been devoted to diplomatic means of settlement. So attention is not made to the diplomatic means of settlement. Do you know what is meant by diplomatic means of settlement?
A peaceful way.
There, some
Not involving court.
of course, diplomatic way of means there may be certain conditions are there in diplomatic way, and there may be possibility way some country may lose and some country may gain. But in the peaceful settlement, it is the parties, they will resolve the issue. So the party itself, they resolve the issue, and hence less attention has been devoted to diplomatic means of settlement. So more attention towards peaceful settlement. So nevertheless, international lawyers have acknowledged that non-binding dispute settlement methods are worth being examined as a source of interstate practices. So binding dispute settlement, non-binding dispute settlement method are worth being examined as a source of interstate practice. The state's action in this field can be presented as a benchmark for the interpretation of some international rules. and even as a driver of the transformation of the international law. See, when you say binding, there is a force. When you say non-binding, it is your voluntary. See, when you want to conduct a farewell party to the outgoing students, so you cannot make the binding to each and everybody to contribute. Okay, according to your capacity, you can pay the contribution. According to the capacity, is non-binding. Binding means every person should have to give 50K thousands. 50 is it's a binding. So better, because we don't know the capacity of a state, capacity of individuals. So make the non-binding one. And it is worthful, and it will be succeeded. Non-binding one is there. Because it is a discretion is given the party. And he himself feel it. Anyway, I am taking one Bombay, this thing, nini, nani, nani. At least I am consuming the 15,000. So better I give the 25,000. So that is a non-binding one. This entry is exclusively concerned with the analysis of diplomatic non-binding means for a peaceful settlement of international dispute. So generally, diplomatic is disencouraged. And what is encouraged? Non-binding is encouraged. That is peaceful settlement of the international disputes. So next is, with the exceptions of general references to the practice of international and regional organization, we don't intend to engage here in a systematic study of dispute resolution within the framework of those organizations. See, there is no a particular way of binding to the parties. You can use flexible methods. And that is not, there is no statutory provisions here. Is there any statutory provisions are here? This so happen. But conventions make certain rules and regulations for peaceful settlement. Based on that one, a country which is the party to the convention definitely will obey it. And both the party will obey it. And there is no binding, no that much force would be made against the parties, because the rules are very much clear there. And hence they will settle the issues mostly in that way. So while diplomatic means of dispute settlement are not exclusively of contemporary international law, so diplomatic means of dispute settlement are not exclusively of contemporary international law. They are growing increasingly relevant in the present moment. It depends upon the two factors. Either the non-binding or the peaceful means, or we can go diplomatic way. In any other means, but only the settlement would be our motto. Within the framework of the United Nations, for instance, the demand for a mediation service has skyrocketed in the last 2 decades. So they say mediation is the best way to resolve the issue and to reach to the conclusion, to reach to the settlement. So mediation has made a dramatic change. That's why I say skyrocketed in the last 2 decades. And the UN Secretary General has referred to mediation as the most promising dispute settlement method. And the United Nations, there is a Secretary General's report on enhancing the mediation and its support activities. That is page number 3, and they are 2009-189, it is given. So what is the best way to resolve the international dispute is mediation. It is a very good. In mediation, he tried to mediate between the two parties and they try to resolve the issues. So mediation is the best way, and which has taken the roots of it, and that is the best way of resolving the international dispute is concerned. So now let us see some other points here, and which I made settlement, yes, only 2. Okay. 646 here. Settlement of disputes in international law. It is a compilation of the Anam Khan from the Hidayatullah National Law University and Sabjit Samanta from the Vikas Bharati Law College, University of Calcutta. So they compiled it where I can make some of the experts from them. So I have to acknowledge, otherwise it will lead to the plagiarism. What are the three types of disputes? Here, review of three basic type of dispute resolution to consider is mediation, arbitration, and litigation. In the beginning, they say mediation. That's why we tell it is the primary way of the international dispute settlement. What are the three international dispute resolutions? There are many types of the dispute resolution process, but arbitration, mediation, and negotiations are the three most common type of the alternative dispute resolution, and negotiation is the least formal type of the ADR. Then which is the sky rocking method for the international disputes?
Mediation.
Yes. Appreciate. So now let us go to the point. The introduction point here is concerned. This notes is concerned with the various ways through which disputes are resolved in the international framework. There are binding as well as non-binding procedures available within the international orders for the peaceful resolution of the disputes and conflicts. Binding and non-binding, both are there. But if you give a discretionary power, or if you give the non-binding to the parties, they will bind more. For instance, there is a biometric is there when you come and when you go to the office. Is it a binding or non-binding?
It's a binding.
But the people will forcefully come and they will make it out and they will chit chat. And in the evening, forcefully they will sit and again they will put it and they go away. But what is the growth? What is the outcome? There is no growth, there is no. But if you give them time, non-binding, they come, even though they come late, they will go late. Or they will complete the work and they will go away. Because they feel a responsibility. So better make the non-binding one, the result is very good. Binding one for those who are the lazy people. For them, they give the target and you fulfill the target. Either you take 3 days or 4 days. Target days is 10 days. Suppose if you fulfill the target within 3 days, increment will be given and marks will be added to you. Because the 10 days work, you did 3 days. That means you made a profit to the 7 days to the company. So they will give in that way also. So they need not to come to the office. They need not to make the punching. No. They can sit anywhere, they can do the work. But the target should be achieved. That is more important. So non-binding need not to come to the office, make the biometric and sit and go away. No. But sometimes they say discipline should be there. But after the pandemic, no. You can do the work from home. Even most multinational companies, those people, because my 2 daughters work in a multinational company, they do work from home. Only the necessity comes over there. Okay, they will meet the clients and they will get the feedback from them. If the client is foreign, they work in the foreign country and they will meet physically there. So why I am giving these binding and non-binding? So more result you will find it non-binding than the binding one. So basically, the techniques of conflict management fall in 2 categories, either diplomatic procedure and adjudication. See, diplomatic procedure is nothing but beating a person with a with a shoe by keeping a quilt. You know quilt? When you bury the mengi with the cold, the quilt will be used over there, the thick one. So diplomatic way also sometimes is a good, and adjudication is a very nice idea. So here, basically the technique of conflict management fall into two categories. One is diplomatic procedures and adjudication. Adjudication, peaceful means. That is a settlement. After both the places it comes to an end. Peaceful settlement of the international dispute is an essential principle of international law that was developed in the United Nations Charter under Article 2, Paragraph 3 on the principle of the international law related to the cooperation and friendly relation among the nations. Diplomatic is discouraged there, but peaceful adjudication is made, and that is the primary settlement disputes in the international law, and which is clearly given in the Article 2, Paragraph 3, that is 2.3, on the principle of the international law relating to the cooperation, friendly relation among the nations are concerned. It has always been the objective of the international law to formulate the methods and means by which the conflicts among the states may be settled by the peaceful means and based on justice. I told you already, the best justice is, say no, the best justice is settlement. So the best justice is settlement for the peaceful means. In this regard, the rules of international law are partly in the form of lawmaking treaties and customs. To achieve that point, the international law is partly in the form of lawmaking treaties and customs. See, customs also given an importance in the international law. And that is because each country custom may be the different, but general customs are the common. Either you take any country. In an international disputes, the dispute must be between the nations in case if a wrong has occurred by the one state. However, it does not become an international dispute till it is taken up by the government of the nation of injured national. That means how many nationals should be there? Two. Not individuals. Nations. One nation to the another nation. One is the injured nation, another is the perpetrator nation. Means encouraging and vexing nation. So thereafter, the dispute must lead to some action by the aggrieved nation. This paper tries to evaluate the perspective of international law and how it would deal with any conflict among the states in peaceful manner. And this article or the paper or the note also talks about the landmark case of Kulbhushan Jadhav, of course, the peaceful settlement of the Farakka barrage gunfire issue. Kulbhushan Jadhav, the peaceful settlement of the Farakka barrage, the gunfire issue, it is an international matter disputed. The role of the International Court of Justice and the Naulila case. So the Kulbhushan Jadhav case and the Naulila case in the International Court of Justice, it is a peaceful settlement is happened over there. These two cases are from India. It doesn't matter. Either you take from Tanzania, either you take from India, or you take from any country. But what we want is peaceful settlement of the disputes. And there, this Kulbhushan Jadhav case, peaceful settlement of the Farakka barrage gunfire issue, and the role of International Court of Justice, and the Naulila case. These cases, along with the other example, have been added for better understanding of the topic. So now the question comes here. Jadhav, you said, whether Jadhav is an individual or he is a representative of the state. Now let us see that how it can. Because as for the International Court of Justice we made, only states should approach, not individual. That means Jadhav did on behalf of the state in one way, in another way. So now let us see the legal and political disputes are concerned. There are legal disputes are there, political disputes are there. In order to understand the process of settlement of disputes in the international substructure, there is a prima facie need to understand the meaning of dispute. I already told you dispute. Dispute is a less time consuming resolving the issue. The dispute has a wide range of interpretation, hence it becomes to give a precise definition of the dispute, the same. In a rudimentary stage, it means a disagreement between the two persons on either the point of law or the fact. The prerequisite for having a dispute in that parties involved must show opposing views. So opposing views should be there in the parties. Then we can say it's a dispute. Dispute among the individuals or between the individuals. And the dispute between the two states, yes, Nile River, it actually comes from where? Nile. Najua, Nilv, Nile, the longest river in the world. Ethiopia. It generates from there, means comes from there and passes Egypt, it passes from the Tanzania and then the Egypt. I believe the Nile River is connected to the Lake Victoria. From there again it passes.
Yes.
The Nile water comes to the Lake Victoria. Okay. But anyway, subject to the correction. That is the way we can say it's a perennial. We did not say lake water would be diminished anytime. The same. Of course, sometimes more, sometimes less. If it rains more, naturally, the local water also catchment area, it goes to the Lake Victoria. Is it? But not sewage water.
Yes.
Okay, anyway, let us see that. In a rudiment stage, it means a disagreement between the two persons on either point of law or fact. The prerequisite having a dispute in that parties involved must show opposite or opposing views. There are two grounds on which the disagreement can arise between the two parties, either political or legal. The distinction between the two is purely subjective. It is primarily the attitude of the states that decides whether the dispute is a legal or political one. So who will decide? State will decide. Who is the state? Court is the state. The court is not the state, but court is the state will make the court. Is it not? So the court will make such a decision. The state will say whether it is a political district or it is a legal district. And yes, later on the international law leads to the legal dispute. So in Nicaragua, where are they? Yeah. The upper point. It is primarily the attitude of the states that decide whether the dispute is a legal dispute or a political one. Owing to the involvement of the states, it becomes difficult to distinguish the two. When the state is involved over there, sometimes it will be difficult to know whether it is a political or the legal. See, for instance, of course, there is no opposing party here. Do you have the opposing party in Tanzania? One is ruling party, another is
political parties. There is.
But there is a strong opposition against the CCM.
In some extent.
Okay. When it comes now, is there any time the other party will be ruling party in Tanzania? Answer is no. From the beginning, CCM only the political party. In case, I'm saying,
Yes.
if CCM is not, any other party has come into the room, at that time they will follow their own ideology. At that time, it becomes a political issue. When the state itself takes, when state itself takes, then political issue become a legal issue. Yeah, at that time, the political issue became a state issue because state's involvement is there. So that way we can say, if it is a primary the attitude of the state, it is the attitude of the states that they decide whether the dispute is a legal or political one. Owing to the involvement of the state, see, I told you, no, involvement of the state, it becomes difficult to distinguish the two, whether it is a legal issue or a political issue. So, for a dispute to be regarded as a legal one, state must desire to settle it on the basis of the law. Political issue, not basis of the law. It is ideology. What ideology? Socialist ideology and capitalistic ideology. So, or else it becomes a political dispute. So, if it is not resolved by the legal issue, then it becomes a political issue. Now, I will ask you the question. Look at me. Listen to me now. Love marriages issue. Is it a political issue or a legal issue or a social issue?
It's a social.
It is a social problem, not legal problem. Is there anywhere legal problem? A Kuriya will not marry the Janja Chaga. There is no such a thing would be there. Irrespective of the caste and creed, one can marry. And irrespective of the nation also. Am I right? Answer is yes.
Yes, Prophet.
So now the dispute to be regarded as a legal one, okay, that is a political issue. However, the distinction between the two becomes extremely important because the procedure for settlement of disputes as laid down in the international law deals only with the legal dispute. Political issues are not covered over there in the international law. Only legal issues should be covered there in the international law. In Nicaragua versus Honduras case law concerning the border and trans-border armed action, the court clearly stated that it is only concerned with the legal aspect of dispute. Okay, now border issue is actually it is motivated with the political, but it is a legal issue. You may ask how? Because when the settlement is there, border settlement, who make the border between the Tanzania and Kenya? Who makes?
The parties
Parties,
only.
people politically they will make it. But when they made it politically, they put it in writing and they will sign. When they sign, it became a legal document and it can be admitted in the court of law. If anybody encroached it, then it is become a matter of fact. Yes, it is a legal dispute. Crossing the borders. And sometimes no, here it is the border of Tanzania, here it is the border of the Kenya, there is a no man's land is there. It not belongs to anyone. No man's land. A person crosses from this border, from the no man's land, it goes to the Kenya border. There you have to take the either, if you are the local, I think you are a paper visa. If you am a foreigner, there is a stamping is there. Some $15, $20 they will take and they will stamp it. Because I have the residence permit of the Tanzania. So now the question comes over here. Two become extremely important because the procedure for the settlement of dispute. But only legal dispute will be settled, but not the political issues. In Nicaragua, Honduras, the case is border, trans-border action, armed cases, and only concerned with the legal aspect of dispute. If a case so arises involving both the political and legal aspect, the court cannot concern itself merely with the political aspect. No. It can see only the legal aspects. The court will see the only legal aspects. In an advisory opinion given in the legality of the threat or use of the nuclear weapons, that the presence of the political aspect along with the legal aspect does not deprive the case of the legal question. Now, nuclear war is there, nuclear weapons. Now there is an agreement. No country should have to make the nuclear weapons. If you make it also, you should use for the constructive purposes. Even India also made it, but they are using only electricity generation, nuclear power for the generation of the other. Because nuclear power heat is more produced. With the heat, thermal. With the heat, they will make the steam. From the steam, it will make the electricity. So in that purposes, we can make it out. It is only the Iraq, yes, Iraq only, that is the war is made over there. And I don't think that other countries following for the nuclear weapons, but if they do also, but they don't use for the war purposes. So now the question comes, the weapons that the presence of the political aspects along with the legal aspect does not deprive the case of legal question. Even the political aspect is there, but it will not deprive the legal aspect because there is an agreement between the nations for the that is non-nuclear weapons. Some convention is there. However, when a question arises whether the dispute of the state are legal or not, then such a question is solved in accordance with the Article 36, para 6 of the statute that says the matter shall be settled by the decision of the court. It will be clear say so, whether it is what type of the dispute would be there, whether legal or not, that can be judged. Article 36, only legal aspect is covered, the political aspect is taken out of it. Statute that says the matter shall be settled by the decision of the court. Therefore, in international law, dispute must be taken in restricted sense. It does not concern all forms of dispute, but only legal disputes. So in the international law, they will make it clear. It will not take the international law, the disputes between the two, wife and husband. Am I right? It takes only the states.
Yes, Professor.
In international law, there have been two methods devised for settling the legal disputes. One is amicable or a pacific means of settlement, and another is coercive or compulsive means of settlement. The compulsive means of settlement is a binding settlement. The binding factors are there. So two methods are there. Which is very best method?
Amicable.
Amicable is the best method. Suppose the other person is arrogant, other state is arrogant, then the second method would be followed. I will give the living example to you. Listen to me. A thief, and everybody knows that he is a thief, and the inspector arrested him or called him. See, say the truth. Then he offered, biryani is very much famous in India, especially Hyderabad, where our state. Hyderabad biryani offered there, and he eaten. Then afterwards, very good Irani chai is very famous. If you go to the India, please take the Hyderabad biryani and Irani chai. Sir, we could not move from the Mohanza, but how could you see that we will fly to India? Please desire big. Is there anybody who force you not to make such a dream? Make a dream. Vision is very good, big good, but no daydream, no daydream. So he offered the Hyderabad biryani, he offered the Irani chai, then Calcutta pan. And he offered, then please tell me whether you have taken the thing or not, stolen. He said no. After some time, no. The policeman has given a big blow on his face. Later he said, yes, sir, I have taken, and I will give you. Why he has not given the earlier? When he offered the biryani, when he offered the Irani chai, and pan, at that time I did not obey it. That means some people use coercive method only, then only they will reveal it. That is the point. Is it clear?
Yes,
Yes,
That is
Professor.
the way. The passive unit of settlement and the coercive method will be used when a person is arrogant, when a person is not, and playing with the attitude of a person, you have to use it. So that is the thing which will make it out. I am sure that at any time it will stop, but before it stops, we continue it. And amicable means, that is, pacific means and a peaceful means. Historically, international law has been regarded as an international community to ensure the establishment and preservation of the global peace and security. Why a UN is created? Anyone? Why a UN is created? There would not be any war among the states, and the people should live secure and peace and healthfully on the earth planet. That is, it is stated in the clearly there in the preamble, the notes. So that is the peace and security is the most. Of course, they are added health also. So the basic objective of the creation of the League of Nations, because 1999 is the League of Nations. But after its failure, why it is failure? Why the League of Nations is failure? Is it the League of Nations when First World War? When? Second World War? Second, the 1919 means League of Nations failed. Then only they made the UN Charter after the Second World War. So United Nations in 1945 has been the maintenance of the international peace and security, and various multilateral treaties have been concluded that aim of the peaceful settlement of the dispute. So the main aim is let the people live peacefully and with security. And there will not be any. When you say peaceful means there is no dispute. Am I right? Peaceful means there is no dispute.
Yes,
So
Professor.
peacefully settlement of the disputes. One of the most important one is the Hague Convention in 1899, and for the peaceful settlement of dispute, and 1907 another one is Article 2, Para 3 of the UN Charter provides that all international dispute must be settled by the member by peaceful means while maintaining the international peace and security. So article clearly mentioned that a peaceful means of settlement would be there among the states, those who are the parties, signatories, member of the international conventions. By peaceful means while maintaining the international peace and security and ensuring justice is not endangered. Justice should not be. And that's why we'll say justice is to be done and justice seems to be done. So that is the idea. The Charter under Article 33, Para 1 enumerates a number of means for the peaceful settlement disputes. So article clearly says the number of ways how a peaceful settlement of disputes could be among the states. Negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to the regional agency are among the few choices they have. So they have the various choices. By that, a peaceful settlement will be happened among the nations. With the various peaceful methods of settlement, the various peaceful methods of settlement can be broadly divided into two categories. Number one, extrajudicial and judicial method of settlement. In law of tort, you might have studied judicial remedies and extrajudicial remedies. Is it or not?
It is.
Judicial remedies by the judicial officer in the form of court. But extrajudicial remedies out of the court. Like in the tort, self-defense. Suppose if anybody enters in your premises, you can eject him. If any trespasser comes, expel him. And if your cow grazes in my land, you can tie the cow till you realize the amount. Distress, damage, fees it. If your tree protruded in your land, you can ask him to cut the branches. If he doesn't cut, you can cut the branches. But your children will not allow you to cut the branches if the mango tree protruded in your. Am I right? Because you,
Yes, yes, Professor.
whatever fall on your land, you are the owner of the property. You did not steal from him. Because the branches protruded, it fell down. And the children, they will enjoy the fruits. So, here say, there are judicial settlement and extrajudicial settlement method also there. So, judicial method is filing the case in the International Court of Justice or tribunal. You know, arbitration tribunals are there. International arbitration tribunals are there. Even Tanzania also party for the convention. Yes, that is binding. Yes. So that is the judicial way. Now the non-judicial method of settlement means mediation. Through mediation, we can make the amicable solution. I don't know whether you have read the case, Bhopal gas tragedy case. MIC. MIC, MIC.
Yes.
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 The case is filed in there in America. Next, they say the cause of action here, and that is the case law is Union Carbide versus Union of India. And India represented the entire on behalf of the all victims. Union of India represent against the company Union Carbide company. The multinational company which will manufacture even battery cells and fertilizers, insecticides, so they will manufacture that. So you know that how the settlement is made? Not through the court. No. Through the out of the court settlement. So they fight it, but nothing has come out. Then the parties sit together, mediated. Okay, this much millions we are going to give you. Then the Union of India agreed, and they deposited each victim on in their bank account the amount. The interest which you will get now, they will take the interest only, they will eat it. So that is a judicial method. Another is extrajudicial method. That is nothing but mediation method, settlement method. So the Geneva Convention, these are all conventions are judicial methods. Geneva Convention, first one is the main Hague Convention. Two conventions are there. One is 1907 and another is 1869, something if I not be mistaken. The Peaceful Convention, two conventions. After the Hague Conventions, where is the Hague? Where is the Hague? Netherlands. Yes, Geneva Convention. The main provision of the Geneva Convention relating to the treatment of civilian persons in times of the war are following. Of course, you know war victims, and civilians also they get they crippled and they will become lame, and some people die. Even civilian also. The opposing aliens who seeks to leave the nation during the war would be entitled to do so, conferred that their fleeing is not contrary to the interest of the belligerent nations. They ought to be allowed to bring along with them a capital considerably essential for their travel and also their goods. You know, when such a thing would be there, belligerents and revolts, when they are defeated, naturally they go back to their own country from where they have migrated. So opposing aliens means foreigners, and who seek to leave the nation, because when they come over there, when they're defeated, they are supposed to go back. During the war, would be entitled to do so, conferred their fleeings as not contrary to the interest of the belligerent nation. So when they are going back, they are not supposed to damage the property of the nation. neither they are take the property of the nation also. They ought to be allowed to bring along with them, okay, something they can bring it, what they earned there. They ought to be allowed to bring along with them capital considerable essential for their travel. Essential travel they can bring them, like the vehicles and the food material and the boxes and the goods and the stationery and the provisions. Yes, they may. So when the matter relates to the national security is concerned, enemy elements ought to be treated in the same way as they were treated during the war. So alien enemies should be treated as if they are treated in the war. In the sense, the equal status should be given, a national security should be given for them. So why? Because of the peaceful making the amicable solutions over there through the conventions. They would be obliged, when the matter is to the nation, yes, that is over. They would be obligated to do merely those duties and to the same extent which would be obtained from the residents of the belligerent nation and their operating circumstances and situation to derive the earning and revenues must also be the same, would not be bound to perform acts and directly connected to the military action. If they come back to their own country, they should be treated like the own subject of their own country. And they will not be given the more work. The same treatment would be there, same amount would be there, same timings would be there. That would be followed up with them. And they would not be bound to perform acts that are directly connected to the military action. No. Military action directly connected, they should not. They're supposed to do in that way. The detention of the alien enemies or their position in an allocated residence should be ruled merely if the security of the detaining authority compels to be mandatory. When they are residing would be there, yes, they have to be protected. They should not be detained over there. The detained alien enemies or their position allocated residence could be ruled merely if that whatever the allocation would be there, that should be given to them, and according to that one, they have to be. So these are all the one point to another point in the Geneva Convention. It is made very much clear to the belligerent and the people, those who are returned to their respective countries with the necessaries they want it for their survival. See, these are all the terms and conditions would be given over there. For what? Peaceful settlement of any dispute between one country to the another country when the country involved in the war. Article 44 of the Geneva Convention provides that the detaining power would not be treated against alien aliens entirely based upon their nationality, statutory of an opponent nation, refugees who don't enjoy the protection of any government. Now, when the people have come over there from the alien, they should be given the equal treatment, and the nationality, they should have to make the same nationality, statutory of an opponent nations, but refugees are concerned who don't enjoy the protection of any government. Refugees at the mercy of the nation. Do you have the refugees in Tanzania?
Yes, Professor.
People from which area? Congo?
Congo.
Still there is disturbances going on those places.
Still there.
But Rwanda, probably they are not African community. There are 8 countries are there now in the African community. Congo is there.
Yes.
South Sudan is there.
Yes, it's there.
But still, they did not send back to their respective countries. It is refugees. That's it. Then who will feed them? Do they work? Or is the sadaqah?
UNHCR.
Okay, that amount will come from there, and the other nations also help them to for their survival. But they do not be given the free. No, they are supposed to work. Refugees are supposed to work there, and they will get the remuneration also. If like laying the roads, or cutting the trees, or making the lanes, highways, Like prisoners, they will take it.
There was a process of making a regionalization to those refugees camp, but the process has not reached to an end.
Okay. So now the refugees cannot enjoy the protection of any government. They said. Protected person shall not be transferred to power that it is not a party to the convention. No. So, however, this provision shall no way constitute an obstacle to the repatriation of the protected person or their returns to their country of residence after the cessation of the hostilities. Suppose the hostility is there, they come over here. But when the hostility is not there, they should be sent back to them, to the respective place. I don't know whether you know it now. At the time I am working in the Eritrea, there is a war. The UN Peace Security Council came. We have given the 3 months salary, asked them to go. Those who want to stay, let them stay on their own risk. Of course, nothing will happen, but what will happen? Instead of that, a rocket goes over there, it comes to this side, and everything will be bombarded. So naturally, I went back. So 3 months salary will be given to us, UN Security Council there, and their deportation was made. If you are an Eritrean, you should stay Eritrean. Suppose if you are married to an Eritrean, okay, wife can stay there, even though she is an Ethiopian. But if you are married to the Ethiopian, you are not supposed to stay over there. You can go back. So there is a deportation would be there. And the people will transfer to the different people. Now the hostilities are not there. It's over. Now they can move together. They can come and go. There is a facility of the even diplomatic relations. Even the planes are coming. You know that Professor Nagusi. Dr. Nagusi is from Ethiopia. Yes. So now everything is normalized. So people will go as it is and come as it is. Good relations would be there. So now why you are saying, the hostilities are over. After the cessation of the hostilities, now the hostilities no more. No Ethiopian, no Eritrean. Everybody is same now. Though in no circumstances shall protected individual be transported to nation where he or she may have a reason to fear prosecution for his her political opinion or for religious belief. Naturally, when a person will be sent, there should not be any prosecution. So, in no circumstances shall be protected individual to be transferred to a nation where he or may have reason to fear prosecution for his or her political opinion or religious beliefs. But generally, a man of the different religion or belief may stay, but if they go back, there should not be any case against them. Because religion, you can have every right to practice your own religion. There is no such a restriction made by the government, or there is no statute also, if they want. So Article 27 to 33 of the Convention apply to persons both in the territory of the belligerent and in occupied territory. These articles lay down the principle of general character. Who are the belligerents? Who will wage war against the state? Are they want to revolt? Are the people coming from the other place, they want to make it internal disturbance to collapse the government? Yes. Who are the belligerents is the question. Belligerents are the people of the same country. Who are the belligerents? A belligerent is an individual, a group, a country, other entity that acts in a hostile manner, such as engaging a combat. The term comes from the Latin bellum gerere, to wage war. I told you, to revolt. Either an individual or a group or a country or other entity that acts in a hostile manner. Other entity means he is not from the same country. Am I right? See, entity is either individual or a group or a country even, or other entity that acts in a hostile manner, such as engaging in combat and make the internal security in danger. So those are called belligerents. So a belligerent is an individual. That's why we can make it. If a belligerent comes over there, when he goes back, yes, he should be treated. That country also should be treated in the same manner as if he is a citizen of that country. So now, here they said protected person, yeah, 44, no? We are doing the 44. Based on the nationality, statutory, and apparent nations, refugees who don't enjoy, no, this is over. We discussed section article 27 to 33 of the convention applies to person both in the territory of the belligerents, yes, and in occupied territory. These articles are laid down the principle of general character. For example, it is provided that such persons are entitled to protect for their persons, yes, and their honor, their religious convictions and practices, and their family rights, everything will be protected for the belligerents. In particularly, no physical or moral coercion must be exercised against them to obtain information. Belligerents, no, it is against the what I say human rights violation.
Torture.
Yeah. The convention specifically prohibits measure of such a character to cause physical suffering or extermination of the protected person. Besides these, collective punishment and all measures of the intimidation and terrorism are prohibited. So they will not be tortured. There will not be any action taken against them. Who? Belligerents. And the major intimidation should not be there. Terrorism not have to be prohibited over there because an amicable solution should have to come out. Cold War. In Cold War also, they will not come out, but they do activities. But the government what to see for such people, either they will excommunicate them or sometimes they eliminate them in the form of killing them. So of course, human rights violations say that because they are making Cold War, because they doesn't like some policies of the government.
Professor, is that asylum seeker? Is that a process of keeping those belligerent, but because most of them, they are asylum seekers?
See, actually, the hostilities are over, or the war is closed over there, or the revolt is over. The belligerent should be treated as a common man. They should not be tortured.
Tanzania.